Thank you for having us.
Sure, and welcome to Vancouver, Clark County. We'll keep it short and kind of informal, but I think before we get to your reason for visiting Clark County, maybe go over a couple of questions that we have about the court. And,
sure.
Feel free to interject on any other topics. I think obviously the first question, to jump right into it, involves the McCleary decision.
What a surprise.
Yes.
Yes.
First of all, in very simple terms for laymen such as myself, explain exactly what the decision says and what it means.
Mm-hmm. Yeah, which I appreciate you asking. We all appreciate you asking. Because there's been much said about McCleary that there's little relationship to what McCleary says. So the decision, which I authored back in 2012, really says that the paramount duty under Article 9 of the Constitution is to amply fund basic education. It harkens back to the 1978 decision, which really set the stage, saying that's an individual right, that people have a right to come to court to enforce, and that the difficult job for a court, if we believe in judicial review, and we do since Marbury versus Madison, is that we have to say what that means. And one of the key features of the discussion of McCleary is the difference between that kind of unusual, unique constitutional provision that says the state must do something, in contrast to what we're used to saying, which is a constitutional provision that says the state can't do something. And
so in our state constitution, it says the state government must.
It says it's the paramount duty of the state to make ample provision for the education of children within its borders, and that's been construed to mean a basic education and to mean K through 12. Before the McCleary decision, it had been construed in those terms. Yes, so it says it's the paramount duty, the number one duty of the state, and that it's up to the court to say what that means. Now, in saying what that means, we've had a history since the Seattle School District decision of deferring to the legislature's definition of basic education. And at the time the McCleary case was pending, the legislature passed the first Comprehensive Basic Education Act. At the time McCleary was pending, the legislature passed a really comprehensive program of reforms. So the decision actually rejected the plaintiff's requested remedy at trial in McCleary, which had been to force the state to go back to square one, to cost everything out, and to make a plan. And instead, what the court held in McCleary is that what the legislature had already passed and was on the path toward implementing would satisfy the constitutional mandate. It had its own timeline, which, if fully implemented, would accomplish its goals by the 2018 school year. And so we retain jurisdiction to monitor that implementation. But it's very clear in the decision that choice of how to proceed and the 2018 deadline was chosen by the legislature, not imposed by the court.
And it seems to me that's where a lot of people get confused.
I think so too.
Well, how do you define paramount?
How do we define that? Well, we define that in the Seattle School District decision in 1978, and we repeated in McCleary. It's the top duty. It's the top responsibility.
But then how does that play out? So now it's the top duty. So from a number standpoint, how does that play out?
I don't know how that plays out from a number standpoint, because I think those are policy decisions from a numbers standpoint, but in terms of prioritization, it's, if it's the paramount duty of the state, it's not something that can be delegated away or bartered away. But it hasn't been construed, for example, to mean that it requires a special fund. This isn't like the 18th Amendment for transportation, where certain revenue sources can only be used for certain purposes. It's always come out of the general fund.
So paramount doesn't necessarily, you're saying it doesn't necessarily define itself as dollars?
No.
So in
just
other
most
words,
important.
Right.
The most important responsibility. That's really how it's been construed.
Well, and it's interesting also because it's the only constitutional provision that has that word.
Right.
So clearly the founders and the constitutional writers intended it to mean something. So out of everything they were doing in the Constitution, that one area, the ample funding of education, was what they determined was paramount. And that's what our responsibility in interpreting and applying the Constitution. is to give that meaning. And in this case, what we agreed with what the legislature said it meant, and we retained jurisdiction so that they would do, in this case, what they had not done in the earlier case, so.
You know, historically too, 1889 is when our Constitution was drafted or was ratified. And if you look during the history of that century, education became a focus of it as a government responsibility. And we became a state during a time when that recognition wasn't as obvious as it is today. You know, education systems weren't provided in a comprehensive way by states, you know, from day one. It really put in historical context, it makes sense why a new state that wanted to be, you know, progressive in educating its citizenry would say that's the paramount duty, you know, by 1889.
This is sort of a bit of a transition from that specific topic, although it does have to do with education. But how does transportation of students play into a paramount duty of education?
Do you want me to go ahead? I feel like I'm cutting.
Could I jump in?
Of course.
Well, just because I asked that question too, way back when, I don't even know when the case was pending or afterwards, and someone said, because the legislature has said it is.
Which is the
Because
best
in my, you know,
answer.
in my day, I walked to school, but my parents drove us to school. If it were raining, there was no busing. I grew up in the South, except to bus the black students past the white schools. There was no busing, no public busing at all. And your parents got you to school. And, you know, that's changed now, and I think part of the reason the legislature said that transportation is an important part of basic education is because our world's changed. It's probably dangerous to have children walking to school in Seattle. I lived in a rural area where, you know, there's a lot of low-income people that needed to be bused from, I mean, we lived 12 miles out of town, although I worked in town, so I could certainly have taken my kids, but I couldn't have taken the whole neighborhood. So it wasn't something, I mean, busing is something I think that the legislature could X out. It's been a problem with, funding busing has been a problem in my community, for example, when the price of diesel goes up really high,
Every community.
and you've got a budget that's been set, you know, for the year before, and all of a sudden you've got this big hit of costs that have to be paid to literally get the kids to school to get them started in classes. You know, where does the money come from? You know, I also came from a community, I'm not trying to talk about myself, but there was a lot of, you know, there's a national forest, there's a national park, there's the DNR, there's a prison. I mean, there's a lot of places that aren't taxed necessarily. So you're not going to be levying on acres and acres of property that could be levied on.
Well, this might be a little out of your realm. It's always weird talking to folks.
Yeah.
You don't talk much, but.
No offense taken.
Unless
Unless it was meant.
What are you gonna do? But it's one thing to say that it's important to assure that the children who need help in getting to school should receive that help because it's a paramount duty to educate students. It's quite another thing to say we're going to set up a bus system, and I don't care whether you can afford private transportation. I don't care whether your parents can get you there. I don't care if this is a disincentive to actually have parents play a larger role. The bus system is for everybody. Get on, enjoy the ride. It's free. Well, it's not free. Taxpayers don't pay for it. And see, that's what I don't understand about the bus system. There's no system that basically is set up the way, frankly, most governmental programs are set up, which is if there is a need, we identify that need, and we help those people who have that need.
Well, though, it's interesting because busing has been such a feature of the states, the legislatively enacted, implemented education program for so long that so many things, including sometimes free and reduced lunch, including a lot of funding formulas are tied to bus ridership. So they've really created a system, not that it's a system constitutionally mandated, and it's certainly not a system chosen by the courts over an objection. So, it's a policy decision that the legislature and the schools have made, but a lot is tied to transportation. You may or may not know, I served on a school board for about 3 terms in northern Spokane, and one of the most important weeks of our year was bus ridership week, when you're counting your students and where they're getting on, because so much of your federal need-based funding and some other funding in small districts hinges on that. So it doesn't have to be that way. It's not a constitutionally directed system, but it's the system that has been created in this state. And, we're certainly aware there's discussion about, reevaluating not just the transportation piece, but, some of the other pieces that have for at least 30 years been a part of the basic education
So if the
program.
legislature came out and said, well, on second thought, transportation is not part of that paramount duty, then that wouldn't have to be part of the funding?
Well, that question has never been
Right.
broached, whether in the modern era you can completely eliminate all transportation and still be meeting the Constitution mandate. That hasn't been addressed by any court that I'm aware of. A lot of education funding litigation is going on nationwide, but whether it has to look just like it looks now, which as Lou points out isn't need-based at all, I think there's a lot of room for reform there.
Now, the court in the wake of McCleary is overseeing the implementation of the decision. How unusual is that? What kind of precedent is there for that?
Well, can I stop and say, I wouldn't phrase it, the court has retained jurisdiction.
Okay,
That's not the same as overseeing
Sure.
implementation.
Sure.
The legislature, the school districts, OSPI, lots of people are overseeing implementation. Retaining jurisdiction is, it is unusual. Courts don't tend, Supreme Courts don't tend to do that. Trial courts tend to do that, not infrequently.
The federal courts do it
Yeah, in federal courts,
regularly.
we look at a lot of reform litigation, prison reform, police department reform, retained jurisdiction's a pretty common feature. The trial judge in the Seattle School District case had retained jurisdiction. The reason this court in McCleary retained jurisdiction was partly in answer to what happened after 1978 when the Supreme Court declined to continue the retention of jurisdiction in the Seattle School District case. And what we saw is that the Supreme Court said, here's what you must do. The legislature then immediately did not do it. And another lawsuit was required to be filed within just a couple, 3 years of Seattle School District. And then, people may not know the history, then Judge Doran, a single judge in Thurston County, babysat that case for about a half a dozen years. So, it's the state's obligation, it's the paramount duty of the state, not the paramount duty of one overworked judge who heard the McCleary decision in King County. And that's really what that's about. But I think it's important that people understand that retained jurisdiction is not the same thing as monitoring implementation. But it does recognize the reality of how long it takes a case to get to the Supreme Court when it's filed in the Superior Court, and how precious every moment is, because this is a big undertaking.
so what are the options if the legislature does not live up to its mandate by 2018?
Well, there we have to be careful, we've retained jurisdiction, and we can't talk about what the court will or won't do. I mean, we can say what has been discussed in the orders in terms of, it's a court order. People come to court to vindicate their
And arrest the chair of the
constitutional rights.
legislature.
Could
Well,
only be contempt.
We
right?
would have authority, we would have the type of authority that you would have anytime a court order wasn't followed. But our hope and expectation is that the legislature will do what it has been ordered to do, and they have some time within which to do it, and they make reports to us. So we have the full panoply of options, and we hope not to exercise them, but we made a decision to retain jurisdiction, so.
Well, since you raised the question of options, what's the worst case option for them?
Well, we'll have to see.
Well,
Well,
you must know your options.
as do you.
No, I ask the questions. What are your options?
Well, we would have you can arrest people, you can fine people, you can, I mean, so you do know the answers.
You can, well, yeah, but
You
that's
can
not.
hold them in contempt.
You can hold them in contempt.
I don't think we can call in the federal troops, so.
So you can't throw them in the who's gun.
Well, we have, people,
You could.
people who are held in contempt can be placed in jail, correct?
Mhm. But
Would
you
it,
know-
would it ever come to that? I don't know. And we're not surmising because we've not made those decisions. And so I don't wanna be a headline that we're gonna throw them in because that's not in fact my goal and expectation is that they're going to do as they've been expected to, and I think they are working hard to try to do that.
Yeah. I mean, as we said in our last order, anybody who's been watching what's happened since even, you know, when McCleary went to trial, certainly well before the opinion issued in 2012, would see that this is a big priority for the state and that this is hard. And, you know, for them, finding the political will
Sure.
and a compromise solution is hard. And saying that something is difficult to accomplish is very different from, you know, saying folks are acting in bad faith or in contempt. But you know, I think the retention of jurisdiction is a good reminder to the courts, to the citizens, that the courts have a responsibility here too. You know, the Constitution says it's the paramount duty of the state, not it's the paramount duty of a single branch of government. And this is everybody's problem, and it's one I think everybody has a strong desire to address.
So tell us a little bit about, and don't take offense to this term, but you're sort of on a traveling roadshow. And tell us a little bit about why you do such things.
Check.
Well,
We've both spoken,
yeah,
so you
we-
speak first and we'll jump in.
We made the choice many years ago, and I've been on the court 24, and it may have been an outgrowth of when the court, the Temple of Justice was closed for about 2 years for renovation and earthquake retrofitting, and they did take the court on the road. And they found it was a positive experience to have the voters and the citizens know really about the court, who we were and what we did, and how important our role was in their lives. And it's almost a civics type experience where we'll meet with students and show them the process that we go through and answer their questions if they have any, and spend the time in classrooms. It is, for all of us, lamentable to think that basic civics isn't stressed in basic education anymore, and so there's often less knowledge about the branches of government, certainly the judicial branch, as we think there should be. So it gives us that opportunity to fulfill part of our obligations as public servants, to educate, to involve, and to embrace the people, so they're just aware of the judicial branch and how important courts are in their lives. We've found it to be a positive experience. I hope for both sides, it is for us, and we're well received and hosted wherever we go.
Well, it gives people a chance to see a Supreme Court argument. You know, not everyone has the opportunity to come to Olympia. Of course, they can watch it on television, but it's really a great experience to be there in person. And unlike in Olympia, when we're doing traveling court, we take questions from the audience, you know, students or community members. They can't obviously ask about the case. I don't think we've ever heard the question, what are you going to do in this case?
Well, we actually do hear that.
We have-
We hear that
we have
question.
heard that question. Politely
It's politely
How many
declined.
stops on this tour?
Well, no, we do three visits a year, one for each term. So you're our only stop. We're here today at Clark Community College at the teaching courses. We'll have an open forum for a couple of hours. We'll meet with the local school community this afternoon, and then we'll meet with the lawyers later on this evening. And then tomorrow we'll have 3 oral arguments. But the actual oral arguments, it's not a mock argument. The attorneys come down and we'll deliberate. And so it's, and we try to move around. We were in Everett last term. Historically, we like to go to one of the law schools each year and then do 2 other visits. We've had budget constraints, so we had to not go on the road for a couple of years, but we're very happy to be doing it again and are very warmly received. It's our second time in Clark County. We were at Fort Vancouver a number of years ago,
Yeah, before I
more
was-
than 12 years ago, because I didn't go. And now we're at Clark Community College, so we're very excited. The paralegal programs are very happy to have us, but any groups. We were with the high schools in Everett. It was just a fabulous,
Yeah, they had
4 different
1,000
high schools. 1,000 high school students bussed in to watch us argue.
Wow.
And they said they really liked it.
Oh, yeah, it's a great opportunity. You know, so many young people you meet who, you know, have an interest in the legal system. They think that it's unattainable for them, and so it's great for them to meet us and hear our backgrounds, that we're just ordinary people. You know, some of us are also the first in our families to have gone to college. You know, that anybody who can do this.
Do
It's
you all
inspiring.
have a favorite strange question that the public has asked?
Favorite strange
Strange
question. We've been-
Well, we had a 15-minute, Ms. Aiken and I had a 15-minute chat about this. I gave her a lot of the background. I'm glad you're all confirming it, because I told her that Justice Johnson would know when exactly it started, but to my knowledge, it'd been over 20 years. But you asked me what typical question was, and we almost always get a question about the death penalty in some form or another. And we almost always get a question about how we pick our cases, because we're sort of discretion and we pick up. So those are typical. The odd questions.
Yeah, I don't think we
got-
get that many unusual ones, actually.
Yeah, we
though.
get some creative ones, I think. That's what I like about going on the road, is we get questions from people that don't think about things like we as lawyers and judges think about them in our very legalistic world.
What about that robe thing? Nobody ever asked you about that?
Well, sometimes
Oh, yeah,
we
we
No,
had
I think
students
that
ask
is, we
us.
have
But that,
been
we don't
asked
think
about
that's unusual.
You don't think that's unreasonable, walk around with those black things?
No, we don't think it's unusual they ask us about it.
Well, if we had to wear the wigs, you know.
Yeah, that would be really unusual.
That might throw it.
But
Throw me.
Yeah, I'll add that the traveling court is consistent with other ways in which we've opened up our court. We had the discussion and we made the decision to allow our sessions to quote the televised on TVW. As far as I know, we're the only state, if we're not the only one, we're the only other couple that allow that. And it's a wonderful education tool for not only lawyers and law students, but just the public. And we are approached often and recognized and complimented on that decision we made. And we're scary enough in the Black Road and intimidating, and people are intimidated when they have to go into court to resolve their disputes. It's a foreign land. They don't understand the language, and the process is uncomfortable, and the legal rights are at stake. And the more confidence that we can instill in the public in our process, the better off we are. Because if we don't have the trust and confidence of the public, it would be a sad loss.
Absolutely.
And Justice Fairhurst has been working diligently with the commission that our court created, the Public Trust and Confidence Commission, to educate people and get our message in the classrooms, on the internet, as broadly as we can. So it's a part of the public service that our offices are obligated to provide.
In fact, I'll just mention, the Public Trust and Confidence Committee, which is a standing committee for the Board for Judicial Administration, in conjunction with TV Washington, just created myths and misperceptions about the Washington state courts. And it's sort of the person on the street with 10 myths or misperceptions, and then judges talking about it. And it's just in its final editing. It will be coming out shortly. I think it'll be very well received and very helpful in helping to educate the public. So we do it individually by going into classrooms. Our involvement with YMCA Youth and Government was just meeting in Olympia and had the mock trial program that I worked with on Friday. There's the iCivics program founded by Sandra Day O'Connor, www.icivics.org, We the People program. So all of these efforts, because at this point it's only a classroom-based assessment. It's actually not even part of the curriculum. And so we really feel we need to have well-rounded students that fully understand their civic obligations and their responsibility as you educate the public about what's happening in your community, how important it is for them to vote and to care and be involved, because it makes all the difference.
Are we the only state in the country with a majority of women on the Supreme Court?
Well, I'm not
think
sure
so.
right
We
now
have
at
the
the
most-
moment.
We have the most women, but I know North Carolina has a majority of women, but they only
There.
have 7 on the court, so they only have 4 women. And our 6th woman soon-to-be justices has arrived, so,
Well, she can come in if she'd like.
yeah.
No, I think she was hoping to interview with you separately since you had not
Well, she'll-
met
But she
her
wanted-
before, but
yeah.
she'd be
She has
happy to come with
because we have
us.
to go, we have
We
to
have to
go
go,
to
yeah.
school.
Yeah.
But I think there are
Judge,
other
you'll leave
courts
in a few
that
minutes.
have majority women. But a few years ago, actually, when Justice
I know,
Parrish
it's
first
12 years
joined the
ago.
court, Justice
Yeah.
Ireland was still on the court. That was the first
That was
time
awesome.
that a court of 9 had that any
Majority of
court had
5.
5 women.
Wonder-
So
Not
that was
many
12 years ago.
Yeah.
Hi, Mary.
Say anything about the evolution of our country?
Well, it's,
Oh, absolutely.
well, I think it's recognizing,
Yeah, so for you. Well, keep in mind that, Chief Justice Barbara Madsen is only the 3rd woman who has served on the Washington Supreme Court. And she joined the court, she was elected in '92, joined in '93. Before her, there was Justice Durham, who was the first female Chief Justice, and then now Judge Carolyn Dennick, who was appointed in 1981. So I think it says, wonders for how far courts, the judicial system has come in really a relatively short time.
Chief Justice Gary Alexander used to describe it as a major sea change. Just the increase in the number of women and now the increase in the number of ethnic minorities that are serving. And I think it's really important that our bench reflect our communities. And I also think it's indicative, especially in Washington where we elect judges, that people like to elect women, and that women also are willing to do public service and to serve in that way. And so I think it's a win-win for everyone. Good. Well, I think we might have to, if you have another question or two, but
No, I-
our group, we have to
Thank you
go.
for
Really
coming.
good
Thanks for
class.
having us.
Thank you so much for having me. It's so great to see you. And if you have any follow-up
Sure.
questions, please let us know.
Thanks.
Be happy to visit with you some more.
Appreciate it.
Great.
Great.
Thank you
All
very
right.
much.
Mary, we'll see you in a little bit.
All right.
Yeah. Goodbye.
Hi,